Good afternoon, and welcome to our roundtable discussion of the future of deinstitutionalization, advocacy, and litigation. I'm Ruby Moore. I'm the Executive Director of the Georgia Advocacy Office, that is the designated independent protection and advocacy system for people with disabilities in Georgia. And I'm the past president of TASH. Today, I'm facilitating a conversation with two very good friends, longstanding TASH members, and disability civil rights leaders, Barbara Ransom and Judith Gran. Their bios were included on the website when you registered, but they'll also say a few words about themselves when they're doing their presentations. I think between the three of us, we have a little over 125 years of experience bringing people with disabilities out of institutions. And it's my job to make sure that today our comments on this topic are limited to 1 hour. So here we go. I'd like to thank TASH and PennTASH for sponsoring this important conversation as part of Disability Pride Pennsylvania's celebration of the 30th anniversary of the Americans with Disabilities Act. It's particularly timely in the context of this global pandemic when there's a heightened awareness of the hazards of congregating and segregating people. So Barbara, would you like to start by giving us a brief intro to the ADA and its importance, especially now, so that everyone will begin on a somewhat level playing field in this conversation?
Sure. Can you see, I'm sharing the screen, I think. Can you all see the screen?
Not yet. I think we can see you, but not the screen.
Okay, let me give that another try. Okay?
Yep, we got it.
Okay, great. Great. I'm Barbara Ransom. I'm an attorney, and currently I am teaching a really interesting course for me. It's about the criminal justice system and autism at Lesley University. And this is like full circle. My first project in the field of disability rights, not the first, but one of the early ones, had to do with writing a very interesting paper on the overrepresentation of persons with disabilities in the criminal justice system. So this ADA presentation is going to include a little bit of that. Many of you know that the ADA was passed in 1990, and a lot of people don't know this, but it was amended in 2009, basically because the courts decided to take on the act and interpret it in its own image. So there was a need for an amendment. The act is modeled after the Civil Rights Act of 1964. And for those of you who don't know this, the Civil Rights Act actually comes out of the 14th Amendment, which allows Congress to adopt laws to protect persons in certain groups of persons who have been outsiders to the American dream. They had decided that in order to curb some of the powers of the state, which had not heretofore been done, that they would implement the Civil Rights Act. In any event, the Civil Rights Act did not include disabilities in its language on its face, but it did include it in its intention, and that intention had to do with equal protection and due process of laws. So we were very happy when we got the ADA enacted in 1990 because that was a special act. It was specially designed to protect persons with disabilities, all kinds of disabilities, physical disabilities, developmental disabilities. But it was to make sure that they became, quote unquote, a part of the American dream. The act does have some of the language and some of the intentions that were set up in the Section 504 of the Rehabilitation Act. So there's a lot of crossover between those acts that Congress enacted in order to make people with disabilities feel a special kinship, feel a special part of being an American, to being in this country, to be part of this country. Um, it took a lot of effort. It took a lot of coordination. There were a lot of disputes. And for those of you who may not know this, when an act is passed by Congress, that's not the end of the story. It's only the beginning of the story. The act comes alive as people begin to use the act and make themselves recipients of the power of the act. It's the easiest way I can think about saying it. The beautiful thing about the ADA, as opposed to Section 504, was that the 504 said that that act only applied to recipients of federal financial assistance or money from the government. The ADA was truly a civil rights act. It was not attached to Congress's spending powers, but it was definitely attached to that clause in the 14th Amendment that said that Congress had the power to create laws to benefit the people. So the ADA took Section 504 a step further than in assuring people with disabilities were included in the society. It's an equal opportunity act. And equal opportunity, when I talk with my students, sometimes I'm amazed with the unbalanced understanding of equal opportunity. A lot of people confuse it with fairness. Laws are meant to give concrete things. A sense of fairness is not always what the law intends to give, but it's something that's measurable, something that's definable. So the ADA is an equal opportunity law for people with disabilities. It was totally new in that sense. It was pushing the envelope a bit further. The Rehabilitation Act really only applies to entities. The federal government isn't supposed to give money directly to the people, but and so when Congress talks about federal financial assistance, or we talk about federal financial assistance under Section 504, we're talking about money that the federal government gives to entities that ties them into obeying certain laws. The ADA went miles beyond that, and it spoke not just to the power of Congress, but to the power of our Declaration of Independence, meaning that everybody is entitled to life, liberty, and the pursuit of happiness. The ADA has three principal titles. Title I deals with employment discrimination. Title II applies to government, whether it's state or local level, and some federal government entities are covered under the Act, but not all. And then Title III, and this is another beautiful part of the Act. Title III applies to private individuals who offer places of public accommodation. So no longer could someone say, well, this is the Lansdowne Swim Club, and it's a private club, so we can say you can't come in here, for example. And the ADA opened up that door a bit further to say, wait a minute, wait just 1 minute. Yeah, you can come in there because they're offering something to the general public. And so we're going to call you a public accommodation for that purpose. And you can't discriminate against people. So the ADA took some of those reasonings from local and statewide decisions and pulled it into the Act itself to widen the doors, to not just apply to state governments, local governments, it also applied to private individual. The thing that I run into problems with when I work with people who don't do a lot of disability discrimination is that they think about the ADA very much, or Section 504, very much like they think about other anti-discrimination statutes. because the other anti-discrimination statutes have prohibitions that say, you public entity, you private entity, you cannot do this. The ADA is a little bit different. It gives an affirmative obligation. It makes, it gives the power to the people to say, wait a minute, I may not be able to come into your establishment because you have these steps there. However, the ADA says if you're opening this place up to the public, you must make a way for me to get into that location. I must be able to have you say, okay, I've got to build a ramp because I'm opening this up to the general public and Barbara needs a wheelchair, so I got to put a ramp in so that she's part of the general public and she can come in. That's a lot for attorneys who have been fighting for years for against discrimination by saying you have to stop treating these people like this. This says, wait a minute, you've got to go a step beyond. Not just that you cannot treat people like this, but you must reach out to change what has happened to these people. And so the ADA is really about refusing to make reasonable accommodations. It's refusing to hire someone with a disability who can afford the essential functions of the job because in your mind, this person has a disability, she's visually impaired, so she can't be a teacher, can she? Seeing the classroom full of students is not an essential function of the job to being a good teacher. Right now, I'm teaching, but I can't see most of you who are in this audience. So teaching is not something where I have to visually see you. The other part of the ADA is about a refusal to engage in the interactive process. If you need an accommodation, it's not just the right of the defendant to tell you what accommodation they will provide. For example, there have been some cases where, okay, we've got a door around the back, so they can come through that alley and get into the premises by going through the back way. That's not what the ADA is all about. That's not reasonable. That's not the interactive process. I don't want to go through the alley to get into your establishment. So the ADA says, wait a minute, there has to be a process where there's a meeting of the mind between the person who wants to get into the establishment and the person who has the establishment. So there has to be what is called the interactive process to make the act work. And that's huge. It's really huge. The ADA also requires accommodations and modifications into the policies and procedures that control how a business is run, control how the government functions, to give the power over the right to say your policies have to be changed was fantastic. Most of us can see the ADA actualized when we walk down the street and we see the curb cuts. Steve Gold, a former colleague of mine, was really very instrumental in making sure that those curb cuts were put into place in the city of Philadelphia. Even getting on a bus, which was something that was denied to people with disabilities. Those are all physical disabilities. And we still have to push the envelope a little bit further because there are ever so many more things that need to happen for people with other kinds of disabilities, people with autism, people with cognitive disabilities. So those affirmative obligations, now I'm talking about Title II, and most of the rest of this will just be about Title II. We're not talking about disabilities in terms of hiring. And I'm not going to talk too much about private entities in light of what this whole conversation is going to be about. I want you to understand, just if you don't go away from this with anything else, please go away with an understanding that public accommodations, government entities, all of those have things that will benefit someone who heretofore has not been able to access the, uh, the benefit, the good, the service. And so the power of the ADA to open the doors, to provide accessibility, to bring people into the general part of our society has been just powerful. So let me, this is the part that really touches me. The United States of America represents 4.4% of the world's population. Of all the people in the world, only 4.4% of them live in the United States. However, the number of people that this country incarcerates is 22% of the world's prisoners. 22% of all the prisoners in the world are in prison in the United States. Between 1980 and 2015, the number of people incarcerated in America increased roughly from 500,000 to 2.2 million. When compared to the general population, both prison and jail inmates identify 32% of prisoners in American jails identify themselves as a person with a disability. 32% of 2.2 million people are people who are in prison have a disability. There have been a lot of studies about people with autism who've been incarcerated, people with intellectual disabilities or cognitive disabilities who have been incarcerated. That's a lot of people. Nearly every person who has an intellectual disability and lives in the community is susceptible to becoming involved in the criminal justice system as either a suspect or a victim of crime. As a suspect, the person with intellectual disabilities is frequently used by other people to become embroiled in the criminal justice system. They're tricked, they're fooled, they're bamboozled. The problem with the whole array of the criminal justice system is that frequently there's not the training to support people with intellectual disabilities, people with autism, people, that's a neurological disability. They are not, criminal justice system is not there to meet their needs. And then we end up with people being incarcerated who never should have been incarcerated. The number of people with disabilities, women most especially, who have been a victim of sexual abuse, rape, or assault, the numbers are staggering in and of themselves. But what is even more staggering is the fact that those numbers show that there's an underreporting of that population because the criminal justice system doesn't pay attention to their need for better communication. Frequently, a person with a disability is an unintentional victim of the criminal justice system because of a lack of understanding and a failure to adopt rules and procedures. A friend of mine, Joan Petrosilia, former professor at in California University of Berkeley, says if a culture is measured by how it treats its weakest members, then the handling of people with cognitive disabilities in our criminal justice system reveals the United States of America at its basis level. Federal and state laws and court decisions have identified prisons as institutions that are covered under the ADA. The ADA is a tool that self-advocates, their parents, their family, advocates, and attorneys can use to ensure that American justice can be at its best. Two famous Supreme Court cases, US Supreme Court cases, I just briefly want to talk to you about. One is Pennsylvania Department of Corrections versus Yesby. And that was the first case that went up to the United States Supreme Court that talked about the ADA in prisons. Justice Scalia, one of the most conservative justices that we've had in the last 20, 30 years, wrote the decision, very tight to the point, very good decision. One of the best decisions I've ever read because it was so easily understood by people who are not part of the criminal justice system. And he wrote a decision that said, yes, prisons are covered under the Americans with Disabilities Act. Prisons do have opportunities to provide services for people with disabilities. There are services within the prison. There are accommodations within the prison. I'm not giving you a primer on how to do it, but I just want you to recognize that there is a need to use the Americans with Disabilities Act for making it possible that our people with disabilities who end up in that system receive the services and supports that they need to be. First, our first job is to say that they don't belong there, but if in fact they are there, and we know that they are, the environment must be able to accommodate them. I want to talk really briefly about Tennessee v. Lane because of the atrocity that happened. A man who used a wheelchair had to go to court in Tennessee, and the courtroom where he had to be was on the second floor. The judge refused to leave his courtroom for this man to have a trial on the first floor. And he said the man could crawl up the steps for all he cared. That is the basis part of our American jurisprudence. So just to recap, discrimination means that the defendant must provide reasonable accommodations. The defendant must alter a program or service if necessary to accommodate people with disabilities. Defendants must engage in an interactive process in order to identify reasonable accommodation, and defendants must alter their policies and practices to provide access to people with disability. We can get injunctive relief from the courts to make these things happen. We as advocates, self-advocates, can ask for them. The first step is to ask. You always must ask. Damages, not so much, but the prospective injunctive relief that is available is a real boon to making life for people with disabilities who may end up in a criminal justice system that has not met its needs in a way that they're not victimized by the system. Did I do that within the time frame?
You did great. Thank you so much, Barbara. I know what a challenge it is to try to bring forth the most important points in a small minute here. So I'm just going to make this invitation to everybody who's a member of TASH or wants to be a member of TASH. The conversation will continue after this. There are plenty of resources on tash.org, and we'll make sure that we push out answers to the questions that people bring forward that they might not have had a chance to ask. For anybody who didn't have the joy and honor of knowing Bob Persky, you might want to follow up and read his book, Unequal Justice. And it touches on some of the issues that Barbara was talking about in terms of how people who are have developmental and intellectual disabilities end up honestly on death row for crimes not committed. And recently, I'll just say, Georgia has just petitioned the court again on this issue. That's a whole nother story. But I just want to say that Barbara has opened the door to some of the intersections that people are a little more conscious of right now because of the global pandemic sort of colliding with what I would say would be hundreds of years of systemic racism also happening at the same time. It's like a hurricane hitting a blizzard. And there's a lot of room there for some conversations as we talk about who gets pipelined to a different kind of future in segregation. and how that gets determined, whether it's segregation in a developmental disabilities institution and a nursing facility or a jail. And some of that is, I'm sorry to say, racially determined, and all of it is horrible. So moving forward in our brief moment here, and to be continued, this is not over, this is the beginning. You're having hors d'oeuvres, we'll have dinner, but this is hors d'oeuvres. So Judy, with the advent of COVID-19 and the medical rationing, the profound discrimination going on, do you want to give us some cultural context to the roots of segregation and the need for deinstitutionalization and making sure that the lives of all people are valued, including people with disabilities? You need to unmute. You need to unmute, Jude. You need to unmute. Okay.
I think of this piece as what is the relationship between the murder of George Floyd on the one hand and the institutionalization of people with developmental disabilities on the other? Or to put it more positively, what's the relationship between Black Lives Matter and the deinstitutionalization movement? And there's a one-word answer, which is eugenics. And the bigger answer is that there was a period in our history that began in the late 19th century in which there was a confluence of similar attitudes toward various groups in our population. Formerly enslaved people and other African Americans on the one hand, immigrants on the other, and people with intellectual and developmental disabilities. And a similar set of attitudes developed based on theories that we can broadly call eugenist, in which certain people were regarded as inherently inferior and subject to being controlled and managed by the quote-unquote majority, the white Protestant majority. And the period in which all this happened was one of great social change, rapid industrialization, the development of the industrial model of public education, which went away from the more individualized approach to education that had been practiced by Quakers and others in an earlier period, and the move toward standardization and homogeneity of public education. This led to the exclusion of children with disabilities from the public school. And as we all know, the Jim Crow laws included racial segregation in education, in public accommodations, and in practically every area of life. And the legacy of that, of course, has continued today in very far-reaching ways. We have all seen evidence of that in police brutality. We are, I think, becoming much more aware of how various public programs that were entitled to benefit people in poverty were implemented in a way that discriminated against people of color and benefited primarily white people, such as housing programs, mortgage lending programs that were subject to redlining and wound up widening the gap and the disparities between white people and everybody else. And around this time, beginning in the early 20th century, state institutions were formed intentionally to segregate people with intellectual disabilities from the general population. And this was justified by the concept that these people were a threat to the wider community, that they were more likely to commit crimes, that they were predators, sexual and otherwise. And there was a big industry of pamphleteering in those days with publications like The Menace of the Feeble-Minded in Pennsylvania, The Menace of the Feeble-Minded in whatever state. And those concepts, the concept that people with intellectual disabilities were going to pass on their disabilities genetically. People didn't know enough, apparently, about genetics to understand that that wasn't true. But all these concepts and stereotypes about the different disempowered groups were very similar. Immigrants were regarded as intellectually inferior. We've all heard about the IQ testing that took place at Ellis Island, in which it was discovered that about 80% of Italians, Jews, Russians, whatever, Eastern Europeans, were intellectually disabled. And of course, that was based on a faulty concept of IQ testing, but it didn't matter. What really mattered was the public perception that it was okay to exclude people, to segregate them. And the institutions were built purposefully to segregate people with intellectual disabilities for life. And they were modeled after plantations, sometimes explicitly. This was explicitly stated, and the idea was that people with intellectual disabilities would be happier and more fulfilled in a kind of benevolent plantation environment where they could do something useful during the day. And we see echoes of this in the current movement, which is quite popular among some families, white families, I might add, in which people are sent to farms, basically segregated in an environment that is supposed to be like a farm, where they can grow things and spend their days, being somewhat, or kept busy at least, in this wholesome, bucolic environment. So I mentioned immigrants, and of course, this period was when immigrants were coming to this country in large numbers, fleeing pogroms in Europe or coming from Asia to work on the railroads and other industries. And this was profoundly threatening for some reason to a lot of white people. And the result was the restrictive immigration legislation that was passed in 1924, which made it very difficult for anyone who was not a Northern European to come to this country. And I think we have seen in more recent years a resurgence of many of these attitudes. Jeff Sessions, who was Attorney General for several years, was explicitly in favor of a return to something like the 1924 immigration law. And we all know about the treatment of immigrants at our borders and the Muslim ban and other efforts based on stereotypes. I don't have to go into the treatment of racial minorities. But I think when we talk about what we need to do to overcome the legacy of this era, and I think the legacy is very much with us, it keeps being reproduced in many forms. Institutionalization particularly continues to be reproduced, and I'm going to give a few facts and figures in a moment. But I want to talk about why I think it's reproduced. I think, first of all, because we have this concept of certain people as being less valuable, as being more disposable than others. And we need to look at what happens in the public education system to see how this is reproduced. Barbara talked about the school to prison pipeline, how people wind up in the criminal justice system and in the institutions known as prisons. And I think this starts very early on in public education, in elementary school. Barbara designed a lawsuit that I helped with years ago in a very affluent school district in Pennsylvania called Lower Merion, a large school district. It had a fairly sizable African American population, and Barbara found, and the statistics verified, that children of color were tracked into lower level classes very systemically. There was hardly anybody in an advanced placement class or a class for gifted students, but there were huge numbers of children of color who were placed in these lower level classes. And children with disabilities, instead of being provided with state-of-the-art interventions, such as, the various reading methods, Orton Gillingham, Linda Mood Bell, and so forth, were simply tracked into the lower level classes and not really given anything but a lower level curriculum. And then when we looked at the identification of kids with disabilities, the white students, many of them, were identified as having autism early on, very early on, and were sent to expensive private segregated schools. The children of color, Black and Latinx, were tracked into lower level classes labeled with learning disabilities and wound up with an inferior education, a very inferior education. And that, of course, has lifelong consequences and shows up in people winding up in the criminal justice system. The segregated schools for kids with certain disabilities, particularly prevalent in the area of autism, those schools are basically feeders for private institutions, which, as we'll see, are really more common nowadays than state institutions. So my conclusion from the history and its legacy today is that we have to tear this regime up by the roots. We have to eliminate it root and branch. And we have to recognize that it's all connected. And that when we struggle against racism, when we struggle against discrimination in housing, in employment, incarceration in the criminal justice system, police brutality, we are helping people with disabilities to become free from institutions, because it's all connected. And I don't think we can remain in our disability silo and say, I only want to deal with institutionalization of people with disabilities. Because if we don't tear this system up root and branch, it's going to continue to reproduce itself. Okay, I'm going to hopefully very quickly run through some visuals of this is how many people are living in institutions today, people with intellectual and developmental disabilities. Well, here's a summary, the most recent data I could find, which was from about 2017. These are people with IDD in state-operated settings, and there are a total of almost 30,000 people with that label, but only 64% of them are in settings of 16 or more. So that amounts to about 19,000 people. And we can talk about what an institution is and the fact that it isn't limited to just facilities of that size. But just to make things short and simple, I'm going to focus on that. This is just a brief overview of the states that have closed their institutions, and the states with the gray lines are the ones that have closed all their institutions. And since this chart was made, we can add Tennessee to the ones that have closed their institutions. So that's hopeful, and we're getting there, but unfortunately, that's not the whole story. There are currently more people in private institutions than there are in public institutions. This is a summary of all people with disabilities, developmental disabilities, and where they are living. As you can see, there are about 39,000, people, little less than 40,000 people in all institutions, public and private, of over 16 or over people. And that means that there are at least as many people in private facilities, not including nursing facilities, as there are in public institutions. Okay, this chart shows the population of people with IDD in nursing facilities. And this is the states. Oh, I'm sorry. Got to go back. Oh, I'm sorry.
Judy, while you pull that up, let's make sure we leave a little bit of time to take the great data you have, the intersectionality that Barbara advanced, and leave a bit of time to talk about how does this inform going forward.
Yes. Okay. Okay. This is the population by state of people in nursing facilities. And as you can see, it varies a lot by state. Indiana is at the top. There is no state that has no people with IDD in nursing facilities. Now, historically, people wound up in these facilities because state institutions were forced to depopulate, partly because of the ICF DD legislation, which offered states money for their institutions in return for certain changes in how people were housed, so that state institutions were forced to place some people in other places because they no longer had room for them. It wasn't a, it wasn't because of the love of their fellow man that states did this necessarily. They were more or less forced to do it. So they dumped people in nursing facilities. And you can see that the most prevalent states by nursing facility population are Indiana, Alabama, Arkansas. There are a lot of southern states that manifest this. Okay, so how does this affect our litigation and our advocacy efforts going forward? And I think we go back to Olmsted, which said that institutional placement of persons who can handle and benefit from community settings perpetuates unwarranted assumptions that people so isolated are incapable or unworthy of participating in community life. Those are powerful words when we look at it in the context of history, which is so profoundly based on the concept of unworthiness, that some people are less worthy than others. And that's why I say, when we fight for recognition of the worthiness of all people, we fight for people with disabilities. The integration mandate of the Americans with Disabilities Act, it's important to recognize it doesn't apply just to state institutions, it applies to private institutions, it applies to nursing facilities, and it applies to other institutions such as board and care homes. And what does it mean operationally? It means that people are entitled to be placed in a setting that enables people with disabilities to interact with non-disabled persons to the fullest extent possible. The holding of Olmsted, states are required to provide community-based treatment for persons, mental disabilities, old term, but this was 1999. When the state's treatment professionals determine that such placement is appropriate, the affected persons do not oppose such treatment, and the placement can reasonably be accommodated. So Barbara talked about reasonable accommodation, so we know what that means. Treatment professionals determine that such placement is appropriate. Well, the vast majority of DD professionals nowadays are going to acknowledge that everybody is better off in the community. And here's where research comes into play. There is a huge body now of research, much of it done by our friend and colleague Jim Conroy, winner of TASH's Lifetime Achievement Award, who showed that everybody benefits from community living, and that the people with the most significant disabilities benefit the most. So although the research hasn't automatically resulted in the elimination of this regime, it has certainly helped when we're in litigation trying to argue that people can benefit. The affected persons do not oppose such treatment. There has been a huge effort by organizations such as Voice of the Retarded, organizations largely led by white parents of people who were institutionalized, to say that that decision should be made by the parent or the guardian. Olmsted did not say that. Justice Ginsburg chose her words very carefully. The affected person, that means the person with disabilities, not the guardian, not the parent, do not oppose such treatment. And that's brilliant because you don't have to raise your hand and wave it and shout and holler and say, I want to move to the community. If you don't oppose it, you get to go. So that's where I think we are now. And turn it back to Ruby.
You need to unmute, Ruby.
It's still, okay. Just on that point, Judy, Sue Jameson, who brought the Olmstead case in Georgia based on two people who desperately wanted to leave an institution and whose treating professionals said they're perfectly capable of benefiting from living in the community. They want to go. There's no reason for them to be here, and yet spend another 18 years being unnecessarily segregated. Sue J always reminds us there's no affirmative obligation for a state to offer segregation as a so-called option. And certainly, to Judy's point, people don't choose segregation when given an opportunity to see what the actual opportunities are. And the community is not an alternative. The community is where people are born, where people want to live with everybody else. It's not the alternative. And thank God for all the work that's going on now in supported decision-making to help kind of move the ball, to help people, whether it's probate court judges or family members or advocates or allies or oppositionists, whatever, to recognize that there are universal human needs and aspirations. Everybody wants, essentially the same things: to be seen and understood for who they are, to have a chance at making a contribution, to being well regarded and respected, to not being unnecessarily segregated, tortured, experimented on, or killed. And that's what we're talking about here. So one thing that gives me hope is self-advocacy and all the things that have been powering up for people's voices to be heard. Another thing that gives me hope is supported decision-making, as opposed to substituted judgment or substituted decision-making. As Judy was pointing out, it's about the person. It's not about somebody else's idea about what they want for the person or best interest for the person. So thank you, Barbara and Judy, for such an eloquent and concise representation of the hope and promise of the Americans with Disabilities Act. Prior to the ADA, we had Section 504 of the Rehab Act. Prior to that, we were bringing cases based on the Constitution, which, by the way, says if you're giving up a constitutional right, it has to be knowing and informed. And we're hearing a lot across the country in various kinds of situations and cases where people are saying, who aren't the person, that that's the person's choice. And so there's probably a whole nother presentation we could do on true informed choice. But as advocates and allies, I think one of our calls to action is to make sure that we make the presumption that people with disabilities want what everybody else wants, and the various kinds of structures and systems that Barbara and Judy were talking about that pipeline people into various kinds of segregation unnecessarily, whether it's jails, whether it's DD institutions, and now nursing facilities where there's a heightened expectation of people dying when being sent there, and when the federal government has so unhelpfully lifted some of the safeguards to keep people out of going into places that are becoming death traps. We've got a lot of work to do, and we really appreciate that everybody came together today to have this conversation. There's a lot of work to do. There's a lot of hope as well. We do have the ADA. We have very powerful advocates and allies, people with disabilities, raising up their voices. And this is a conversation that bears continuation. we've been trying to manage the chat as we go along. Some people have asked for basically the outline of this presentation. I'm sure we can make that available to you through TASH, and the data that was also contributed. Thank you, Judy. We're just very happy that you came today. And if Barbara or Judy want to say one last thing before we close, now's the time. You have to unmute, Jude.
I'll let Barbara go first.
Well, as you guys probably guess, I'm really passionate about the need to deinstitutionalize prisons. I think that the criminal justice system, in and of itself, is a hellhole, and we really need to look at ways that we can dismantle. I think that that system breeds war crime, breeds sexual abuse, and the people who are most abused in prison are people with disabilities, not only by the other prisoners, but also by the guards who are overworked, underpaid, and are facing monumental challenges to the job that they do. They are not capable of being supportive to that segment of the population that's there who has disabilities. And we need to think very seriously how we can change that system of incarcerating people with disabilities.
Yes. I came across a statistic recently that 1/3 of all people who are murdered by police are people with disabilities. So that's something to bear in mind. I think the the coronavirus has really highlighted what we've always known about the harms of institutions. Um, for the, I don't know, beginning around the mid 80s, we began to really focus on the inherent nature of congregate settings and how they lead to harm by their very nature. You can't fix them up. You can fix them up within an inch of their lives. You can pay $1,200 per person per day, which was the cost of care in three of the institutions in which I've recently been involved in litigation. But you can never eliminate this. And one of the things that COVID has highlighted is the risk of infection and contagion is huge in congregate settings by their very nature. In the mid 80s, we had a case in Oklahoma that went to trial, and we called a sanitarian, a former public health official, as a witness, and he went through the institution. He found so many unsanitary practices, and this in an environment where people who were tube fed, who were on ventilators, people who were very vulnerable were housed. And the lack of sanitation was really pretty deplorable. And it's because those places are inherently hard to keep free of germs and sanitation. And the stereotype was, well, you know, institutions are like hospitals. They're nice, sterile places. You know, I won't go into the risk of contagion in hospitals, but which we know exists. But the stereotype was that these places should be more sterile and more sanitary than a home. And the sanitarian said, oh no, the risks are much less in your own home because you don't have zillions of people coming and going from one building to another, spreading infection wherever they go. In a smaller, more intimate environment, it is much easier to keep people safe and free from harm. So as we go forward, I think we'll continue the strategies we've developed for revealing to courts and the public at large the harms inherent in congregate settings, and maybe focus on the risk of contagion a bit more than we have in the past.
So I just want to say that thank you to the interpreters for staying over an extra minute or two. Thank you for everybody participating today. And I've heard a rumor that there might be part 2 of this conversation, since there was way too much information to try to squish into 1 hour. But I really appreciate Barbara and Judy, first of all the work that you've done over many decades, and secondly, coming today and trying to, as concisely and as possible, talk about the excruciating reality of how people are being harmed systematically, and at the same time, the hope and the promise of the ADA and the Constitution itself. So thanks, everyone. We have to sign off here, and we hope to talk to you soon. There will be additional information on the TASH website and hopefully on the Penn TASH website. If you're not a member of TASH already, please join up, because there are many, many more resources that are regularly made available on these topics, and people who've been working on these issues for a very long time, bringing forth their best understanding of how we can move forward. So thank you, and be safe.
Thank you.
Thank you, everyone.
You're welcome. Bye-bye.
Bye-bye.
Thank you, everyone.